Okay, and I'll start us off. Welcome, everybody. You are here with me, Nadia Mercer, the Executive Director of the Greater Brookland Village, and Michele Zavos from Zavos Law. And I will introduce her shortly, and she'll take it from here. But I just wanted to do a little Zoom 101. Anyone who needs it, which is please keep your cell phone. Ooh, there was some echoing here. Please keep yourself on mute, and then if you would like to change the view of your screen in the top right corner, there's something that says view. And if you click on that, you can see the gallery view, which is everybody on the call and all of our boxes and names and faces if you have your microphone on or your camera on, or you can be on, you can click speaker view, which will just be the person talking. So that's up to you. Another thing, Michele Zavos is inviting you to use the chat. And typically for me, the chat is in the chat bubble. You click on it, it's in the bottom. And then you can write questions throughout the presentation if you would like. And then we will reserve answering. She might answer a question along the way or two if it fits in with what she's talking about in the moment. Otherwise, we'll reserve a question period after the presentation. And then I'll read through the questions, or you can just announce them yourself at the question and answer period. Okay. Anything else about Zoom? Anybody have any questions about Zoom? Someone is calling me. Okay. So I will go ahead and introduce Michele now. So Michele Zavos is our presenter for this very popular workshop on wills, trusts, and estate planning tonight. I think this is the most people we've had attend one of Greater Brookland Village's Zoom workshops ever. So this is a record. Michele Zavos is a longtime Brookland resident, Brookland, DC, that is, and she has been practicing law and has been an estate lawyer in Brookland since around 1979. Is that right? So 40 years. She's a graduate of Catholic University, and yeah, I'll let her take it from there.
Okay, thanks, Nadia. Hi, everybody. Glad you're here to hear about all this, because there's a lot of confusion out there about estate planning and what it means and how you do it, and should you just use LegalZoom or anything like that. So I'm going to go through all of it, and I know Nadia sent out my estate planning guide. And I hope you all have either had a chance to look at it or can pull it up on your computer to see it. What I'm going to try to do is, to some extent, follow what the guide did, but it's not to be used as a be all and end all. I like to talk and tell everybody. I don't want you to just read this thing and not listen to me. I have lived in Brookland since 1979. I graduated Catholic, the Law School of Catholic, in 1979. And I've actually been doing estate law and sort of everyday law for people since 1982, when I joined a very small firm after I worked for legal services and clerked for a judge. So what I like to do is go through, what does estate planning mean? I always start with the will, because that's the thing that people are most interested in. And I assume, does everybody live in DC? Some people live in Maryland. Anybody live in Maryland? Okay, I'm going to assume everybody's in DC. Laws are somewhat different in the jurisdictions. You know, DC is a little bit different than Maryland. Maryland is different from Virginia. But what I'm talking about is, oh, all of a sudden I see myself. What I'm talking about is how this generally works, okay? And if you do live in a different jurisdiction, the best thing is to talk with an attorney from that jurisdiction. I'm going to give you an overview, and I will certainly answer general questions. I cannot answer specific questions about specific situations because I don't have a attorney-client privilege with you. And then anything I talk to you about on this call would be public, and that's not an appropriate way for an attorney to work. Okay, so first thing is, what happens to your assets at the time of your death? You know, nobody likes to think about that, but it's called adulting, if you've come across that name before. We all have to think about these things. And, you know, it is a misnomer, misconception that everything is dependent on a will. It is not. So what happens at the time of death is anything you own individually with just your name on it, if you own a condo or a house, a car, whatever, that is generally has to go through this process called probate, which is the transfer of assets and payment of debt through some sort of supervision of the court. Now, DC, surprisingly, has one of the easiest probate laws in the entire country. It consists of filing a petition for probate, listing any individual assets that do not have beneficiary forms, and I will get to that, and also listing your debt, and if you have a will, you attach the will. Now, this is where I ask a lot of people, how many of you have a will? And, you know, you get a couple little hands. But the fact is, even if you have not proactively written your will, you have a will. It's just that the District of Columbia is going to write it for you. And you may or may not be happy with it, but you don't have a choice. It is written a certain kind of way, and everybody gets the same will. When you proactively write your own will, you can write whatever you want. It's not like in France or European countries, you can't disinherit certain members of your family. Well, you can here. You can. If you're married, the spouse will have certain rights, but even so, you can totally minimize what the spouse would get. So DC, you filed a petition for something called abbreviated probate, which tells the court in lay terms, don't bother us, we won't bother you unless there's a problem. The court says, great, because we don't want to do these things. And what that means is you do not have to file an inventory of everything you own and accounts of what happens to all those assets. When I was a young lawyer in 1982, we didn't have this law, and you had to go sit down with a deputy register and had to go through every penny that was in the estate and had to account for every penny. It was beyond ridiculous. So now you don't have to do that. Then there's a notice that is published in 2 legal newspapers and general instructions that are sent to people who either would inherit from you if you didn't have a will, heirs, or inheriting from you because you do have a will, legatees. Basically to tell them, you know, you've been named, here's what you need to do if you want to make any claims, all that sort of thing. And then that gets filed. It's the only other filing, and you're done. That's it. That's all of probate in DC. So if you hear people saying, like our friend Susie Orman, who is not a lawyer, saying things like, you should have a revocable living trust and avoid probate at all. Wrong for DC, completely wrong. If you read my estate planning guide, there's actually an article in there that was commissioned by, I think, the Maryland Attorney General about these revocable living trusts and why you either don't need them or shouldn't do it. What any trust is a set of instructions on how money should be spent when you no longer fully control it or control its form. So there are irrevocable living trusts, just like they sound. You create it, you cannot amend it, you can't change it, you can't do anything with it. We used to use these for tax planning, because when I first started doing this, the federal exemption was $675,000. What that means is you got a spousal exemption. Any money going to your spouse did not was not subject to estate tax. But any money going to anybody else, there was a limit of $675,000. And after that, your estate started incurring estate tax. Now, the exemptions are in DC, $5.5 million. We still have the complete spousal exemption. And on the federal level, it's $11.5 million. And on the federal level, it's what we call portable. If you are married, you die, you leave everything to your spouse, you do not use up any of your $11.5 million. Your spouse, at the spouse's death, will have an exemption of $23 million. So almost no one I work with has that kind of money, right? Most of us, we don't have that kind of money. So we don't have to worry about estate tax. It's just not an issue. So for almost everyone, I think the last time I did one of these irrevocable living trusts was for somebody who had a life insurance policy of $9 million. So we wanted to keep that out of his estate. And you do that by putting it into an irrevocable living trust. And then at his death, it will not be taxed. That's probably been, I don't know, 6 or 7 years since I've done that. So I don't think anybody on this call needs to worry about paying estate taxes. If you do, you can call me and I'll send you to somebody downtown who does this sort of thing, okay? And it's very expensive. It can cost $20,000, $30,000 for somebody to do your estate planning in order to avoid taxes. So we don't have to worry about that. Trusts, as I said, notwithstanding Susie Orman, we should not, I think, we shouldn't be doing revocable living trusts. What those are, revocable, just like it sounds. You can change it, you can amend it, you can do anything you want because you still own the assets in that. That's why it's revocable. You own the assets, you're taxed on those assets. It is just an extension of you. People would do these revocable living trusts in order to avoid probate. In DC, there's no reason to avoid probate. These revocable living trusts cost about $3,000 to create. And then once they're created, you have to move all your assets into the name of the trust. So for example, Michele Zavos, just to make something up, would not own her house. It would be the revocable living trust of Michele Zavos would own her house, okay? And here's the thing, you know, I've been doing this a long time. And upon occasion, I do have people come in and they tell me they have a revocable living trust. I say, okay, great. Show me Schedule A. Schedule A is where you're supposed to put all of the assets that are in the name of the trust. There's always $10. Why? Because the $10 was used to open a bank account. And then there's nothing else. And I say, so, you know, thinking maybe they just didn't redo the Schedule A. So where's the rest of the assets in there? And they said, and this is true. What do you mean? And I said, well, you know, you're supposed to move all your assets into the name of the trust. And this was with a couple, and one turned to the other and said, honey, weren't you supposed to do that? Nobody ever does it. It is too complicated. And we have enough complicated lives, enough things going on. You're just not going to do it. So you have all these people I have worked with just wasted $3,000, and I have ended more revocable living trusts than I have ever written. So I don't recommend them. You can look in the state planning guide, read that article. I think it's a very good article. Now, if you're talking to a friend, I don't know, who lives in New York, my understanding is probate is complicated in New York. So maybe a revocable living trust makes sense there. It does not make sense in DC, because estate planning laws are all dependent on the jurisdiction where you live, right? So if you live in DC, that's one thing. If you live in Maryland, it's something else. If you live in Virginia, it's something else. So right now I'm talking about DC. The times when a revocable living trust might be appropriate, let's say you are so fortunate that you have a house in DC, you have a house at the beach in Rehoboth, you have a cabin in West Virginia, and maybe you have an apartment in New York. You are very fortunate, right? Well, here's the thing. Real property is always probated, meaning transferred, where it is situated. So you'd have to do a probate in DC, then you'd have to do what's called an ancillary probate in Delaware, another ancillary probate in West Virginia, and another ancillary probate in New York. I have never met anybody like that. But, you know, it's as a hypothetical, that's where you might want to think about using a revocable living trust to avoid having to do all these ancillary probates. People also use revocable living trusts for elders, right? You know, a parent may want to have a revocable living trust, so when the time comes that she doesn't want to have to be responsible everything, there's another trustee, and that trustee will manage everything, and she doesn't have to do that anymore. When my mother was alive, we talked about this, and instead of doing that, what we did was powers of attorney on all of her assets. And I'll get to powers of attorney, and I will talk about that. But for revocable living trusts, you know, it is something to talk about and see if your particular situation lends itself to one of these things. You know, maybe you feel like, yeah, I'm getting older. I don't want to be responsible for all this. I want my son to manage it all for me. That's a way to do it. But you still have to move all those assets into the revocable living trust. Otherwise, it's useless. Okay. Now, in DC, what's interesting is, I don't know, it was maybe about 4 years ago, DC changed its laws so that you can actually put a beneficiary right on the deed to a house. So for example, if I owned a house by myself, I don't, but if I owned a house by myself and I wanted my daughter to inherit that, I would re-record my deed that says on it, beneficiary is Addie Leader Zavos. And then that piece of real property, my house, does not go through the probate process. It makes things much easier. I was just talking to a neighbor today about this, and he's like, oh, wow, that's a really good idea. I said, yeah, it is a really good idea. It is not hard to do. I don't do that work. I send people to title companies because they do this all the time and it's much cheaper. So what the title company will do is create the deed and then file it with the DC Recorder of Deeds. And then your real property is not part of your estate for probate. So most people, we can set up their estates in such a way that there's no probate at the time of their death, because the other tools we use are beneficiary designations. So for example, retirement, if you still have life insurance, most investment accounts and even bank accounts can be made pay on death, transfer on death, or you fill out a beneficiary form, like for your retirement. And those assets then go directly to that beneficiary. They do not go through the court, because the court knows exactly where those assets need to go, because we've got a beneficiary, right? That's why the deed for your real property, it makes it so much easier, because the court looks at the deed. The court has nothing to do, you know, it says right on the deed who that property goes to. So if you do your deed, if you happen to own property, and you make sure you have updated beneficiary forms, you don't put your estate, unless you're leaving things in a very complicated way. But let's say you're just going to leave it to your kids, or you're going to leave it to your best friend or something like that. It's very easy to just put those on beneficiary forms. And then you go into the bank and get a pay on death or transfer on death, POD, TOD form. You fill that out. The bank has it. You keep a copy. And at your death, if you still have that account, it goes to that beneficiary. Okay, so it's much, much, much easier. Now, let me talk about retirement for a moment, because people always kind of wonder what happens with retirement assets at death. If you have a spouse, the retirement assets can be, I'm sorry, I just saw something on the chat. The retirement assets can be rolled over into the spouse's own retirement funds. No tax consequences, right? Just rolled over. If you leave retirement to someone other than a spouse, it's called an inherited IRA. And that beneficiary must take that money out over a period of 10 years. And interesting, can wait, till the 10th year and do it then, but it must come out over 10 years and is going to be taxed at whatever the beneficiary's rate is. Otherwise, if the money comes out of your retirement, 401k, 403b, IRA, SEP IRA, all of that, if the money comes out, it will be taxed at that moment. Whatever you as the decedent made during that year, that's going to be the tax amount. Okay, so that's why, mostly the name of the game is to push the tax consequences into the future as much as possible. Just push them into the future. So with a spouse, that's easy to do because the spouse just rolls it over. With someone other than a spouse, they have that 10-year period in which to pay off. So I just want to ask, somebody asked, let me see if I can do this. In the, if you do a will, say in DC, and you move to Virginia, is it going to be valid? Yes, as long as it's valid in the jurisdiction where it's signed. Okay, so yes, it's valid. So somebody else just put, a neighbor who was moved from DC to Texas by her nephew died 2 months after leaving. DC probate judge is now requiring proof, not surprising, that she was still domiciled in DC. How does that work if one were to leave home and move to Maryland care and maintain DC real property? So the probate judges get very knotted up about these kinds of things. It's complicated in that you have to say you were domiciled in DC. What does domicile mean? It means that you lived in DC, but even if you left to go somewhere else to reside, you intend to come back to DC. DC is your home state, your home jurisdiction. If you are elderly, and you've moved, say, somewhere to be near kids and you're in assisted living, then the court is going to say, well, we don't really think you plan to come back to DC. And that's going to be what we call a question of fact. I can't say in every situation, this is what's going to happen, right? But yes, the judges are going to look at that. The judges in DC for probate, and please don't repeat any of this. Sometimes I wonder if they have enough to do because they get so nitpicky about this stuff. Why should they care? But they get really nitpicky. Okay, so that can happen. So somebody just asked, will it still be taxed if it's a Roth IRA? No, because a Roth IRA is taxed before it goes in, and it's not taxed coming out. 401ks, 403bs, you know, they're taxed. You get a tax break putting in, and they're taxed when they come out. Okay. Sorry, I'm trying to see how I can scroll down because I see there's some other questions out here. What proof is then needed to show intent to main domicile? You know, you're still paying taxes in DC, you have a home in DC, you're paying taxes on your home, you travel back to DC. I mean, there's so many possible elements to this. I can't say it's this, 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 and this. It's not possible. And frankly, the judge gets to decide. You know, I mean, that's the thing. People, I think a lot of times are confused and they say, I have this right. Well, you know what? Under our law, you don't have any right till some judge says you do. So if you say I'm domiciled in DC and the judge says you are not, guess what? You're not, because that's what the judge said. Okay. All right. So a will is very important because, and if you look, if you have my estate planning guide, if you do not, again, proactively write your will, you die what's called intestate, meaning without a testate, without a testamentary document. So when you die without a will, as I said earlier, DC or whatever jurisdiction you live in writes your will for you. And I'm just trying to go to that part in my estate planning guide that says, you know, if you have a spouse, your spouse gets it. If you have a spouse and kids, I think it's 2/3 to the kids, 1/3 to the spouse. But if you bear with me just a minute, I'm getting there because I don't remember these things all the time off the top of my head. I think that's a function of getting older. So let's see. And this is all in the code, just as the taxes are in the code, all of that. Okay, in DC, if you are survived by a spouse and no surviving children or parents, your spouse gets all of your estate. Whether you have made a will, I mean, if you haven't made a will, that's what happens. If you are survived by a spouse and children, the spouse takes 2/3 of the estate plus a home credit of $15,000 and a family allowance. Children get 1/3 of the estate. Now, here's the other thing that's important. If you have minor children and your minor children inherit without a will with a testamentary trust for your children, that's a problem because here's what happens. Let's say a kid is 15. The money that would go to the kid is essentially locked. Nobody can get that money unless they go into court and somebody becomes the guardian of that money who can then spend the money on behalf of the kid. But the other problem is when the kid is 18, the kid gets all the money. So think about that. I had a neighbor, and everyone knows I'm a lawyer, and she came running out and she said her sister had just died and left a very modest estate of $90,000. The daughter was 19. She inherited the $90,000. The daughter and the boyfriend were out spending money, you know, like water, right? They're 19. And she said, what can I do? What can I do? And I said, you know, neighbor, I'm really sorry, but there's no law against being young and stupid. Right? So the advantage, and you know, kids, my daughter's 37, and kids are younger, I think, than we were somehow. I don't know why, but they just are. And so most of the time, I will recommend to clients that a testamentary trust for children, and children get like at 25 or 27, 30, 35. So I once had a client say, no, they don't get any money until 50. I said, please consider that. That's a horrible message to your child, but okay. So what a trust does is the children or whoever is the beneficiary of the trust own the use of the money. They own the money, but they can't spend it. A trustee owns the legal portion of the money. So, for example, if you've got kids, you name a trustee, and this would have applied to my brother, who is a complete and total car addict, crazy person about cars. If he had inherited any money from our parents without a trust, he would have had whatever the best Porsche is in the world in his, for him in a nanosecond. But if there's a trust, he has to go to the trustee, because the trustee is the one who has the right to spend the money. He has to go to the trustee and say, I need a car, and I need it to be a top of the line Porsche. The trustee says, okay, I do think you need a car. We're getting you a beat up Volvo. Saved him from himself. That's what happens. So let me continue to go through this because some people have asked some questions. And remember, this is in the estate planning guide. So if you are survived by a spouse and a parent, you would think you would think that your spouse would get it, right? No. Spouse gets 3/4 of the estate plus 15,000 and a family allowance. Parents get 1/4 of the estate, right? You didn't proactively write your will. This is what happens. If you are not survived by a spouse or children, then surviving parents take equally, or if there's only one surviving parent, all goes to the surviving parent. If there are no parents, then goes to the brothers and sisters. Somebody asked that, Wendy. It would then go to the brothers and sisters. So you have to go, kind of far down the line. No spouse, no kids, no living parents, then you get to siblings. Okay. Let's see. Okay. So in Maryland, just as an example, it's different. Even if you're married, I had a case like this. It was horrible. These people were married. They had been married, I can't even remember, was it 4 months or something like that? Was it 4 years? I can't remember, but they had not been married long. They did not do the will, of course. They had not been married long enough for that part of the statute to kick in that said the spouse got everything. They were short, I think it was 1 month. So it turned into a whole terrible thing, a fight with the decedent's parents. If they had just done their will, none of that would have happened, right? None of that would have happened. And so, and people think, oh, I'm young, or oh, I'm healthy, I don't need a will. Well, we all know you never know, right? I had a client, it was horrible. He was like 42 or 43 years old, worked for the federal government. I had worked with him and his partner. I had done an adoption for them. I had done their estate planning. I had talked to them about buying more life insurance because I didn't think they had enough. I'm not a financial planner, but I do this work. And they did all that. Well, one day he went out to go to work, and nobody knows how this happened, but somehow he was at the back of the garage and the car hit him and killed him. Just on his way to work. And somehow the car, nobody knows what happened. It was horrible, horrible. But fortunately, they had done the estate planning and he had bought extra life insurance. And so the one thing the partner and the son didn't have to worry about was money. They were set. So they could just deal with his loss. And he was 42. I mean, it was crazy. So we don't have crystal balls. We never know what's going to happen. And that's why it is important to take, and I'm that's in a minute. But somebody just asked, can you say something about trustees when there are no family members or friends to appoint? Yes, it's always better to have family members or friends. It depends on the circumstances. But some lawyers will act as trustees, and banks have trust departments. They get paid, so it is somewhat costly, but they do work. So, there are always those options if you need them. Okay, so I'm going to move, I think, now to the documents you use while you're alive, healthcare related documents, and why they are important. So the first one I talk about is healthcare power of attorney. So what is that? Power of attorney is a document that says, if I am incapacitated and unable to make any decisions about my medical care, then I appoint someone to do that for me. I am called the grantor or the principal. The person I appoint is called the agent or the attorney in fact. So the idea is the grantor, the principal, becomes incapacitated, cannot articulate her wishes. So the agent or the attorney in fact has to step in and say, what do I think Michele would do here? And that's what they're supposed to do. Does that work? Of course not. They don't know, but they're supposed to use their best judgment. And, we've created these things because we need a context. We need to be able to have these decisions made. So that's the healthcare power of attorney. Now, one of the things with any power of attorney is, yes, it becomes operative at the grantor's incapacity, but then the question is, do you have to prove incapacity? And if so, how? Well, here's the thing, especially around medical care, the doctors are going to be talking to you or trying, and they can see you can't respond. So you don't really need to prove anything. And then if you did need to prove it, I think all of us know doctors trying to get a letter from a doctor or an affidavit is just impossible. So the way, at least I write mine, is I don't require proof. Because you're not going to name somebody who, I don't know, is going to do something crazy, right? So this is very important. And, it always comes back to me. I had a call from a client just a few days ago. I did their estate planning many years ago. And one of them was in the hospital. I can't remember what it was, but some horrible thing that was happening to her. And the spouse was trying to get into the hospital, see the records, be able to talk to the doctors. This is a spouse. They would not let the spouse do that. So she called me, the spouse, in a panic. I know you did them. I don't know where they are. Do you have them? Well, it so happened I did have them. I save everything on a server. But then she found them. But she was a spouse, and the doctors gave her a hard time until she came up with that piece of paper. So it's important to do these documents because you never know. Most of the time, at least in my experience in DC, you come in and you say, hi, I'm the wife, I'm the husband, I'm the wife, whatever. No issue. But every once in a while, you run into somebody where it is an issue. And there's nothing you can do about it unless you have that document. Also in the document, we put whether you're willing to be an organ donor, what kind of funeral, or, you want your body cremated, you want it buried, you want what's now called a green burial. So we put all that in, and it works. I've never had a problem with somebody using one of these healthcare powers of attorney. In addition to the healthcare power of attorney, we do something, somebody said, and if no spouse, parents, or friends, another option is charities, of course, but you have to write your own will to leave money to charities. Otherwise, they're going to find your long lost second cousin, and that second cousin's going to get your money. Okay. Then if a property was bought prior to marriage and both names are on the deed, and both names, does anything need to be done to update the deed to reflect that we are now spouses? You don't have to, but I think the best thing is to, yes, have that re-recorded that you are now spouses. And here's why. If you are not married and you own a property with someone else, you can own it one of two ways. What's called tenants in common, where the fiction in the law is that you own the individual portions of that property, or joint tenants with rights of survivorship, where the fictional law is you each own every little molecule. And when one of you dies, the other one automatically becomes the owner of everything. With tenants in common, you die, your share goes to whoever you've said in your will, or again, if you haven't proactively written your will, what DC says. The advantage of changing that to what's called tenants by the entireties, which is a type of tenancy that is only for married couples, or in DC, domestic partners. The advantage of that is when you get married, you're in this marriage box, right? So the property is then owned by the marriage. So if somebody sues you individually, you don't own that property. They can't take it because you don't own it. The marriage owns it. So if somebody sues you, there's this extra layer of protection. So it is a better thing to be tenants by the entireties. I mean, after marriage equality came, and I have a lot of clients in the LGBT community, I told all of them to go and get their deed re-recorded. You don't pay taxes on that because you're just changing the form of the ownership. So, you go to a title company, they redo it, they file it, now you're tenants by the entireties. Okay, I'm going to add this one more right now. If you add a beneficiary to your deed now, does the value of the house have more capital gains? No, that's for the beneficiary than if instead given at death. When you put a beneficiary on your deed, the beneficiary gets the property at death. And I understand the question behind that because, and I hope none of you have done this. If you live in Brookland and you've had a house for a very long time, I bought my house at $68,000, 1982, right? What's it worth now? Well, let's just say $1 million. Well, let's forget about all the money I've put into it, right? But let's just forget about that for the moment. The capital gains is $68,000 from $1 million. So it's what, $932,000. The way capital gains are taxed, if you are married, you get a $500,000 exemption. So now we have what, $432,000, right? Capital gains is 15%. So whatever it is. Now, if, and I've seen this, I put somebody individually and I wanted to give it to my daughter. And this is estate planning by internet. I put her on the deed so she would inherit right at my death and there didn't have to be any probate, right? Wrong. Why? Because when I bought that house, it's $68,000. That is the basis, the cost basis, right? When I sell it for $1 million, the gain, the capital gain, is that $932,000, right? Well, if I put her on the deed, she gets the initial cost basis, just like me. See what the problem is? Whereas if she inherits it at my death, she gets the fair market value at my death, which is $1 million. So there's no taxes, no capital gain taxes that way. I had a client here in Brookland. I hope it's none of you. I don't think it is. Whose father owned a lot of properties here and had owned them since the 50s. So you can imagine what those gains were, right? So she did estate planning by internet and she put herself on every deed. So she now has a capital gains problem, right? And she told me to fix it. And I said, I'm sorry, I can't, and we're not working together. There's nothing that can be done. You've already done that. So don't do that. You've thought about it, don't do that. So that's, I think, what the question was. All right, here's one more on this. If you have a non-IRA mutual fund and have designated beneficiaries, persons or charities within that mutual fund, not in a will, then who makes the mutual fund follow your instructions. They have a beneficiary form. You know, presumably the beneficiary will know they're a beneficiary and they contact them. They have no choice. Sometimes these companies are pains in the neck and a lawyer has to call them, but the law is very clear. It has to go to those beneficiaries. Okay, so let me get back to the healthcare stuff, and we're going to save the rest of this for later. In addition to a healthcare power of attorney, I have clients do a separate living will, also called a declaration. What is that? That is a document that says, if I'm in a medical situation in which every attempt to cure my condition has been made, and those attempts have been unsuccessful, and there's no reasonable, very important, reasonable hope of my recovering any quality of life, also very important, I authorize, not I require, I authorize the cessation of life-sustaining treatment. This is what people refer to as the pull the plug document, right? It's not exactly that, but sort of. If you want someone to be able to stop life-sustaining treatment, like nutrition, or you're on a ventilator or something like that, you must have one of these documents. There are certainly hospitals, you know, you're 99 years old and yeah, they'll probably do it. But mostly they won't. Somebody will be forced to go into court and get a court order. So when you have one of these documents, the person you have chosen to be your attorney in fact, or your agent, will make these decisions. You know, nobody really knows what's reasonable, what's quality of life. So that's left up to your attorney in fact to make those decisions. Okay. So it's very important. I'm going through here. Then a HIPAA. Somebody asks, if you have a power of attorney, do you need a separate HIPAA document? Yes, unless your power of attorney references HIPAA. HIPAA is the federal law that says your personal information cannot be disclosed without your prior consent, right? If you do not have that authorization, I don't care if you're the spouse or the son or whatever, doctors are not supposed to allow you to see any medical documents, not supposed to give you any medical information. But if you have the HIPAA and you've named your attorney in fact, and I always put a secondary attorney in fact, then those people will have access to all your records. That's important. Some people put it in directly in the power of attorney for healthcare. I do that, and I do a separate document just to be sure. The next document I do is what I have termed a final arrangements designation. What that document is, under statute in DC, you can name someone to essentially take possession of your body at your death and determine burial, cremation, green burial, all of that. But what this document does is it gives the holder, or the person who's named, the authority to deal with the funeral home or whomever, the hospital, whatever. I think it's really important because sometimes we had a case many years ago with my firm where a young man committed suicide. He had done 2 tours in Iraq and then he committed suicide. And his family had thrown him out when he came out as gay. And so he went to a different family when he was in high school, and he lived and grew up with that family. And he wanted them to have his body. He wanted them to bury him. Now, he had not done a specific document, but we had emails with all of it. We had a trial. The biological family came up and wanted his body. And I think they somehow thought they were going to get money. I think that's what it was. So we had a trial, and it was the first thing in DC, where the judge found that the emails constituted a final arrangements designation. And so the family he grew up with got his body, took him back, South Carolina or something, and had him buried in a family plot there. So that's, just to show you how important those things are. And you just never know. You just don't know what's going to happen. And so I think it's really important to, control. what potentially can happen and to protect yourself as much as you can. So somebody said, what about a what is the proper timing of getting that from your doctor? I don't know. It depends. It all depends. People ask me all the time, should I get a do not resuscitate order? And the answer to that is, it depends. If you are 95 years old and you are suffering, then maybe you do want a do not resuscitate. But if you were like my brother and had a heart attack and they resuscitated him at 62, I think you want to be resuscitated. So it just depends. What I put in my healthcare power of attorney is that the agent or the attorney, in fact, has the right to determine whether there should be a do not resuscitate order. And that's in conjunction with the doctors. When my mother, who was almost 95 when she died, and she was totally cogent till the end, if something had happened to her, we knew she wanted to die, no resuscitation. She would have killed us if we resuscitated her. So, that's the kind of thing you have a conversation, you talk, and the do not resuscitate orders only really come up when somebody's very sick. Somebody is very sick and they're not going to get better, and they don't want to go through the suffering. Okay, somebody asked, do taxes have to be paid on my personal belongings? Depends. If you don't have probate, no, you're just not going to do that. But anyway, let's go to the next one, which is the general power of attorney, which is for finances, right? So you are in a situation where you can't manage your finances, you name someone, agent, attorney, in fact, to do those things for you. What I always recommend to everybody is you also talk to every financial institution where you have money, because every financial institution will have its own power of attorney for finances, general power of attorney, and they want it blessed by their lawyers. This was so bad in Maryland that Maryland passed a law that said basically, banks, you have to honor outside powers of attorney. So the one I do is sort of an umbrella, take care of everything. But then I have people go to the bank themselves. I've had a couple situations where, people are at the bank, they won't honor your power of attorney. All right, let me talk to the legal department. And, we go back and forth, back and forth. And finally, it is honored, but it's a pain in the neck. So I try to make this as easy for everybody. And that's one of the things that you can do. Now, if you have minor children, probably none of us do, but if you did, if you have kids who have minor children, in DC, you can do something called the designation of standby guardian. And what that is a document where the parents can name what's called a standby guardian. In DC, I think the guardian has legal authority over the children for 3 months. If 3 months goes by and the parents are not able to take care of the kids again, then the guardian has to go into court to get a court order. This document came out of the AIDS epidemic when women were losing their children to foster care and couldn't get them back, even when they were well. So people thought of this document, and I think almost every state has now adopted it. All right, so let me look at these for a second. There are some groups like 5 Wishes that provide several options for setting forth more specific situations for healthcare decisions. That is true. Personally, I don't like them. And the reason I don't like them is because you cannot predict what the circumstances are going to be. And that can lock you in. And I just don't think that's a good idea. I think you want to rely on your spouse, your best friend, your child, whatever, to try and figure out those things given the circumstances at the time. But everybody, has different feelings about that. Then what do you recommend about care for a surviving pet? We we don't have pet trusts in DC. There are in Maryland, but generally what I will do is say, you know, if at the time of my death I have any animals, I direct that they be placed with, you know, my good friend Michelle, and she be given an amount of $10,000 for their care. And that's fine. That's always worked. It's not a problem. You have to have a lot of money to create a pet trust, a lot of money. Most people don't have that. So that is, I think, right on time. Pretty much what I wanted to present. And so then I'm, you know, open to questions at the end. You know, we've dealt with some questions as we've gone along, but the floor is open for questions.
I have a question.
Sure.
My name is Shubh Sheesar. Good evening. My
Hi.
name is Shubh Sheesar. I lived in Texas, Austin, Texas, with my husband almost
Okay.
for 25 years, and he died last year.
Oh, I'm sorry.
And thank you. I moved to DC because both of my children live here and they work here. So
Yes.
I am here. We already had a family lawyer who made my will and my husband's will also.
Yeah.
So
Uh-huh.
my lawyer called me the other day and she said Texas will not work in DC. So I have to make a new will. So that is my question, that do I have to make a new will?
Well, DC recognizes
Okay.
wills that are properly executed in another jurisdiction. So I'm not exactly sure, but there could be some elements, you know, of the will that it's easier to have a DC will. I don't know.
So what should I do? I should, is it possible to make my own small will and get it notarized, or
No,
what is your advice?
No, you go to a lawyer. Please don't do this
Okay,
on legal
okay.
Zoom or anything
Because
like that.
I'm
So
here.
for example, DC does not require a will to be notarized. There have to be
Oh.
2 witnesses over 18, not related to you.
Yeah.
And they have, and it has to be signed in a very specific manner. Everybody has to be in the room at the same time. There are certain questions that are asked of the person signing the will, and you must do those things in order for the will to be valid. So
I am very new here. I am
Sure.
only not even a year here.
Yes.
And I have no idea about the legal team or whom should I hire or what should I do. So that, okay. All right. Okay. Thank you. Thank you.
Sure.
Thank you.
Sure.
Thank you. Are you in DC?
Yeah, I'm in DC, in Brookland.
Okay.
Yeah.
Okay.
So Nadia, can you give them my contact information?
Yes, I
Yes,
will send a follow-up email to everybody with Michele
Yes.
Zavos's
I will
contact
take
information.
Nadia.
Sure. Sure.
Thank you. Thank you so much.
You're welcome. Dolores?
Yes, thank you. I was trying to find the hand to raise and I couldn't. Okay, so I have chosen the personal representative to oversee everything.
Right.
So I'm a little confused because I will be going through probate, and I really am and hopeful because you said it's pretty easy in DC, and I do live in DC. But if you ask them to let the personal representative, because I have a very detailed list of what they're to do they really follow if you have and they would, I guess, turn that over to probate to a judge and say, well, here's what she's asked. They follow.
Is that in a will? Did you put these things in a will?
Yes.
Right.
I will, and part of the will said he is to be the person.
Okay, but did you have it executed before 2 witnesses?
Yes.
Okay, did a lawyer do it for you?
No.
You need to have somebody look at it. So just so everybody knows, I realize I didn't talk about this. The personal representative used to be called the executor. We now use gender neutral terms. The personal representative is the one who manages the transfer of assets, payment of debt pursuant to the will or pursuant to intestate succession. The personal representative has to be named or has to be appointed by the court. The personal representative has to be a US citizen. And yes, the personal representative is supposed to follow the wishes. If the wishes aren't followed, a beneficiary can come and say, you know, she's not doing the right thing or whatever. There are many cases like that. unfortunately. But if you have written the will yourself, you really need somebody to look at it.
I see.
Because there are potentially things, for example, when your witnesses signed, did they initial every page?
Yes.
Good for you. Did you initial every page?
Well, I had had a will before, so I knew what it was.
How to
what
do it.
Kind of
Yeah.
how to do it. It was just that a lot of the things have changed because things change
Yeah.
over the years.
They do. I always tell my clients to renew your documents every 5 years. Because things change and doctors don't want to see a 10-year-old power of attorney. You know, so yeah, it's important. I think you should have somebody at least look at it.
Okay.
Okay.
And you are available to do that.
Possibly we have to see.
Oh,
It depends.
Okay. Okay,
Because
thank you.
I will tell you, I never work off of anybody else's documents. I've been doing this 40 years. I have the documents I like. They're
Right.
done the way I like them. But contact me, we'll see.
Okay, thank you.
Sure.
So I see someone has their hand up. Margaret?
Yes, can you tell me if the personal representative has to be a resident of the District of Columbia?
Does not,
Thank you.
but has to be a US citizen. Anybody else?
No questions are dumb questions.
Yeah, please.
Okay, another hand up. Donna?
The question in the chat about free will, I wonder about that too. Free will, and is there some other online will documents, trusts? What do you feel about those, and are they legal? Will they be recognized?
First of all, you're talking to a lawyer. I hate them. You know, because people, you don't get the benefit, at least the way I practice law, you don't get the benefit of a back and forth. Somebody talking about your situation, what's the best, you know, all of that. And sure, you can go on LegalZoom or one of those places and do a will and forget about it. And, you know, at your death, if that will is not a good will, you're leaving all sorts of problems for the people who survive you. You know, I know people don't want to spend money, right? I get that, but it's important to take care of yourself
Yes.
and your loved ones. It's really important. And, you know, that's a decision you have to make.
Before we get to Lorna's hand up, there's a question in the chat. Michelle, can you give
How much does it
ballpark
cost?
About, yeah, how much
I can
does
tell
it
you
cost?
exactly. I charge flat fees. I do not charge hourly, no. So for a couple, spouses, I charge a flat fee of $3,850 to do 12 documents, right? Wills, healthcare powers of attorney, living wills, HIPAA documents, final arrangements, designations, and general powers of attorney. And it's a very, as you can see, I'm going to take a very holistic approach and go through everything, and beneficiary forms. For Brookland and greater Brookland residents, I charge $3,500. For an individual, I charge $2,850, same things, but for greater Brookland, I charge $2,500.
25.
And here's the thing, I mean, there will be other lawyers who are cheaper than me, absolutely. And there will be other lawyers who are more expensive than me, absolutely. But I know what I know, and I've been doing this a long time.
I would like to have you.
Okay, Lorna.
Thank you very much. I'm still learning things. My question actually goes to what one can do to make the personal representative's life easier. So for example, if they live out of state, are there certain things like itemizing what your most valuable items are, have appraisals prepared? What kind of documents, other than the basics that we've talked about already, would be helpful to make their job easier?
Yeah, the first thing is to try and have beneficiaries for every asset that you can, including a house. If you live in DC, you own a house in DC. And when I do estate planning with people, I then send them basically an organizational chart. How to make things easier for everybody. Passwords, assets. I did the probate of my mother's estate and loved her to pieces. She was incredibly organized, and she has 17 bank accounts. So, yeah, we never talked about that.
So is there
I-
one place that you could recommend that would have all of that information?
I will send it to Nadia if you want to, if that's okay, Nadia, and you can
Yes.
send it out. There are a couple of tools like that are useful.
Okay, thank you very much.
Thank you.
Sure.
Okay, we have Nancy next.
Yes, hi.
Hi.
I have, excuse me, I have 2 adult children, early 30s, lovely people. One lives here in DC, one lives in another state. For example, for the personal representative, do you just have one? For the person who's the agent in case of, your health agent, you just have one?
Right. And here's the way I do it. For the personal representative, you name somebody, but then you name a second. If the first one is not willing or able to do it, it defaults to the second one. Sometimes I've put 3, defaults to the third. On the powers of attorney, for the attorney in facts, same thing. You put a primary, a secondary, and sometimes a tertiary. And the reason for that is if you have to have 2 people making a decision and signing all documents, it's a pain. It's just not a good idea.
And they might disagree too.
They might disagree. That's exactly right.
Yeah,
That's exactly right.
thank you.
So it's better to just have one. It cuts down on the family trauma.
Okay, we have a question from Bob Hoffman.
Can't hear.
Bob, you're on mute.
Yes,
Okay.
2 quick things.
There you go.
I wanted to clarify that I own a house that has a lot of appreciation as well. And I have not put my son, who I want to get the house, on the deed. And the reason I have not put him on the deed is I have him as a beneficiary for exactly, I think, the reason you were saying about capital gains.
Absolutely, and that's the right thing. But now, if the house is in DC, you can make him a beneficiary directly on the
Yes,
deed. He's
he
not
is.
an owner. He only gets the house at your death.
Exactly.
Right.
All right. Second thing was that I had a full will that was done by my lawyer. And then I went back and he said, I'd like to take the will and put the entire will into a trust, word for word, but do put it into a trust. What's your thinking about that?
I don't recommend it. He's talking about a revocable living trust.
Yeah.
Again, you have to move all your assets into that trust to make it effective. And probate is so easy in DC. Why would you do that?
Okay. Very good. Thank you.
That's my feeling. And most, I work with a lot of financial planners, and almost all of them take the same position as I do because they see it too. All these revocable living trusts that are not funded.
And if I die in Virginia, that's not going to make any difference on anything, right?
No, not if you're a resident domiciled and residing in DC.
Right. Okay. Thank you.
Sure.
We have a couple questions in the chat. One was directly to me, but it's not for
Yeah.
me, so I'm going to read it out loud.
Put your hand in there.
It says,
Let me
what
have-
is your recommendation designating POAs for healthcare and financial decisions for those of us who are single without children or family in DC who do not want to burden friends with the responsibility? Do
This is way
state
too lazy.
attorneys or caseworkers do this, or are there other options?
Good
It's a
question.
hard question. I mean, first of all, I don't think you should worry about burdening people until you ask them. Most people are more than willing to do this for their loved ones, their friends, whatever. So that's the first thing I would do. Healthcare decision-making is very difficult because social workers aren't going to do it. My sister's a social worker. You're not going to do it. it's such a personal thing that I can't say, it's like a bank where there's a trust department and who's going to be able to do those things. I don't know that. People say, well, will my doctor do it? No, your doctor will not do it. So you really need to talk to the people closest to you first.
Okay, before I get to Danette, I just want to tell everybody that I will send you Michelle's contact information and her
Yes.
fees or rates after as a follow-up.
Sure.
If you own property in Virginia.
Okay, we're gonna go to Danette, whose hand is up, and then the next person. Oh, and then
Suzanne is
Martha.
up, Martha.
Okay, Danette and then Martha.
Hi, Michelle. I was wondering, is it better to have an estate if you have multiple properties, or will just a will take care of the needs of a property going to different individuals?
Okay, let me see if I understand your question. If you have multiple properties or you want to leave properties to multiple beneficiaries, should you do a will? Probably yes. It depends, but probably yes. On the DC deed, you can have more than one beneficiary. For example, you put a beneficiary on the deed, I leave this property 50% to my daughter and 50% to my son, something like that. You can do that. So it really depends on the circumstances. I'd have to know very specifically to be able to really answer that. But yeah, in a will, there are various ways you can deal with property. You can say, I direct that my property be sold and the sales proceeds divided between whomever, or I want to give this house just to my sister, or something like that. It just depends.
So if you don't want your property sold at all, that is that better to have it in an estate type of situation?
No, you can, if you don't want it sold, the example of, yeah, I want to give it to my sister, you have to understand that your sister might sell it because she's going to own it. So
I can't direct them to say, you cannot sell this.
No, unless you put it in a
estate
trust,
plan.
that's a different
Oh, in a
circumstance.
trust. Okay.
Yeah, and you say it can't be sold. Now, I would talk to somebody a lot about why you say that. But yeah, that's the kind of thing where you really need to talk to a lawyer about it.
Okay, thank you.
Sure.
Okay, Martha, patiently.
Yes, two questions. I live in DC and have a property here, but I also have a property in Virginia, or part ownership of a property from an estate in Virginia, and I have property on the eastern shore of Maryland. At this point, they're all in a trust. Is that the best way to have handled that?
If they're already in a trust, I wouldn't change that as long as they really are in the trust.
Okay, yes, yeah.
Yeah.
Okay, and the other thing I would say to the person who was asking about people with authority, I am one of two power of attorneys for a almost 98-year-old. She also has a medical power of attorney. We work as a team. She is somebody who never married, has no close relatives. That's something to consider because it works very well.
Yeah, although I still, it's great that it's worked. I would not recommend that two people have decision-making authority.
Okay, if we're all members of the same church and it has, it's a lot of responsibility and it helps to share it.
Yes. Yeah, I can understand that. Yeah. I think Suzanne, did we get to you?
No, mine is a little sticky. I'd like to leave some money to someone whom I suspect but do not know is not legal here.
Okay, I'm going to stop you right there. Because I cannot respond to a question like that.
Okay,
I have to know more facts. Yeah. And, I don't respond to specific questions like that. I can't. If you want to call me, I'm glad to talk to you, but
Yeah, okay, no, okay.
Yeah.
I understand.
Nadia,
Okay.
Alan Ingber, could you put me in queue? I have a quick question.
Go ahead.
Okay.
Go ahead.
About 10, 12 years ago, I had a very good attorney, Ann Walker Webster, do all my last will and testaments, powers of attorneys, etc. She moved from Washington to Virginia. I had last year, I had to have everything redone. But I signed them in Virginia at her office. Is that okay?
Yeah, that's okay.
Okay, okay, that was it. Good answer, thank you.
Okay, we have,
Okay, somebody asked, can you repeat the name of the document that gives a person the right to take care of the body at death? I call it a final arrangements designation. I made it up. We used to call it a bodily disposition document. People didn't like that, so we changed the name. So yeah. And then Donna Lee, I see you. I see the question. You've got to call me. I can't answer this.
Oh, okay.
Yeah, you got to call me. I can't do that.
All right. Good seeing you.
Good to see you. Any more questions?
Yes, whoops.
okay, was that Lorna? Who
Yes,
just-
yes. Yeah.
Okay.
Again, I'm trying to think about making it easier for the personal representative. So I'm wondering if you have an idea of how much money they would need to be able to like pay continuing co-op fees until you're
That money comes, yeah, that money comes out of the estate. The personal representative is not individually liable for anything that you incur. The personal representatives in DC have a right to be paid from the estate.
Right. So would it be prudent to put aside, let's say, enough money into a joint bank account so they could access, let's say, a year's worth of co-op fees until the real estate can be sold, or how?
No, if you make it joint like that, the other person then owns automatically half of that. I wouldn't do that. You know, all these mortgage companies, banks, everybody, they're used to people dying. You know, the money will be available to do whatever is necessary.
But that's not.
Again, another suggestion, you could give the bank the payable on death ability on an account.
Yeah. Yeah. I mean, the easiest thing for a personal representative is to not have to go through probate. So you make everything beneficiaries, pay on death, transfer on death. And if you own property in DC, this does not apply to Virginia or Maryland, but if you own property, you can put the beneficiaries directly on the deed.
Well, but
I mean, I appreciate, Lorna, what you're asking, but you know, this is a normal process that all of these organizations, associations go through. So somebody asked, what's the best way to leave assets to nonprofits? Through your retirement, because retirement is taxed twice, right? It's potentially taxed as part of your estate, depending how much money you have, but it's also, unless it's a Roth, it's taxed for income tax purposes. If that goes to a nonprofit, there's no tax levied on that asset. Okay, that's the best place to leave those things to.
Thank you. We have two hands up, so I want to make sure to get to Alice Walker and then Michelle Hicks.
Hi, Michelle.
Hi.
You mentioned green burial. Could you explain what constitutes
what this means?
Green burial?
There was just a big article. I knew I should have cut it out. But essentially what it is a mechanism by which your body is turned into soil and put in the forest to grow things. I think if you Google it, you'll see, I knew I should have cut that out, but a lot of people are opting for that. So, you know, cremation actually is not good for the earth. Burial is not good for the earth. It takes up space. So this green burial idea is coming out if you can manage that.
Okay, thank you.
Sure.
Michelle Hicks.
Hi, thank you so much, Michelle. It's really great information. So
Sure.
I just thought about this. Okay, I'm at 53. I'm unmarried. I have an adult son. The question is, if I do the will now, then everything goes to him. But if I get married, do I need to do a prenup and then change my will so that my son gets all of my assets?
You know, that's a very specific kind of question, which the same thing, I would like you to call me. I'm glad to
Okay.
talk to anybody for 15 minutes. But I'd have to know a little bit more about that.
I guess my main
But yes,
question is,
if you're going to get married and you already have assets, yes, do a prenuptial agreement.
prenup.
Absolutely. Yeah.
Okay, thank you.
Somebody just put on here that article I referenced was in the Post. And so in the chat, it shows how to get to it. And then somebody says, the only cemetery in DC that is green burial certified is Congressional. So.
Okay, we have about 5 minutes remaining. I will send out an email after this or probably tomorrow, once I get all the follow-up information from Michelle.
Yes.
Does Alice have her hand up
I
again?
think she already asked her question.
Okay.
Sorry about that.
It's okay. Yeah, so everyone will get the guide again if you haven't already, and Michelle's contact information.
Yes.
And then there was some more things that you were going to send me, Michelle. I think something about how
The organizing tool, my contact information, the fee structure.
tool. Mhm.
Yes.
And then somebody else said in the chat, another option is donating your body to medical research. Doesn't matter what your health situation is. Yes, medical schools would love to have your body. Somebody asked, does the DC medical examiner need to see every dead body? I don't know the answer to that, but I doubt it.
No,
What? My 80-year-old father's body was not accepted. Oh, to a medical school?
Mhm.
Okay, well, it depends. You know, what I have my clients do is, if they want to do that, is to contact particular schools and see what language do they need, who will take it, all those things.
My experience as far as medical examiner seeing the body here in DC was not the case at all.
I'm sorry, say that again, Suzanne.
The medical examiner does not need to see everybody.
Yeah.
In my experience,
Yeah.
my husband died at home. At hospice, there was no need to involve the district.
Yeah.
I think if it's thought to be homicide or some type of natural cause, then other than that, you don't have to have the medical examiner see, from my understanding.
Yeah.
Okay, we have a hand raised, Jamal Smith.
Hi, this is Ashley, his wife. But I just had a question about, I know you said it before, I just want to clarify. You're saying for a deed, if you add somebody's name to the deed, then you're subject.
Wait, stop right there. There are two separate things on a deed. One is adding somebody's name to the ownership.
Okay.
The other is adding somebody's name as a beneficiary. Those are two very different things.
And you're saying when you add them as the ownership, that's subject to the capital gains, but to add them as beneficiary, it is not, correct?
Correct. That's
Okay.
right.
Thank you.
Sure. Any last things?
This is Dolores. So I just paid for my cremation, so I just want to say what they told me.
Prepaid.
Yes, I prepaid. So if you die at home, my personal representative is supposed to call Metropolitan Police Department because they have to come before the body can be released to the funeral home.
No.
If you in hospice, if you die in hospice or you're in a hospital, then a medical examiner is not called. But you call the Metropolitan Police Department if you live in the district and you would die at home by yourself and you're not under medical care. I mean, you're not under hospice. So that's what I was told. It's a procedure because they cannot take your body otherwise without the medical examiner making a decision that nothing happened to you. They may decide, they said that there will be an autopsy, or they may just come look at you and send you right to the funeral home. That, at least I'm just sharing that from Fort Lincoln for anybody who might be interested.
They want to make sure that there was no foul play.
Yeah.
I mean, they want to make sure there's no foul play.
Exactly.
I live in an apartment building where I've had several people who have died alone, and you call the police first and they take it from there. Now, whether it has to go to the medical examiner or not, but somebody who dies alone in an apartment, the procedure is to call the police.
How do they find out what your final wishes are?
If you've done your documents, somebody will find them. Otherwise, they won't know.
So actually, that raises an interesting question. Who should have copies of your documents?
Yeah, I go through that when I do the estate planning and I tell people
Yes.
who to give copies to and everything. Yeah.
Okay, well, thank you, everybody, and thank you, Michelle.
Thank you
for
so
this
much.
Very
Nadia. Thank you.
clear presentation, very helpful, and we'll follow up with an email with all her information.
Okay.
Yes, thank you.
Thanks, everybody. Take
Thank you,
control.
everyone. Thank you
Make
very much.
decisions.
Thank
Have
you.
a safe and happy holidays.
Happy holidays to you.
Bye.
Bye-bye. Thanks.
Thank you.
Thank you very much.
Thank you again, Michelle.
You're welcome. We'll talk.
Okay, good night.
Okay, thanks. Bye.